All right, let's dive into one of the absolute best moments in any courtroom drama, that big, show-stopping confrontation. You know the scene, right? But do you know the real rules that make it happen? Let's get into it. We've all seen it a million times. The lawyer pulls out a letter, a diary, some bombshell piece of paper, and boom, the witness is caught in a lie. It is fantastic television, for sure. But the real-life legal dance behind that moment is honestly way more interesting, and it has this surprisingly messy history. So how do you actually use someone's past words against them in court?
To really get today's rules, we have to go back in time and meet the villain of our story. It's this super old legal ruling that for more than 100 years actually made it harder for lawyers to get to the truth. It's known as the rule from the Queen's case.
Okay, so this old rule was incredibly simple and just terrible. Imagine you're a lawyer, and you've got a letter that completely blows up a witness's testimony. Under this rule, you couldn't just ask about it. Nope. The very first thing you had to do was walk over, hand that smoking gun to the witness, and let them read the whole thing.
And look, I'm not just being dramatic. The entire legal community hated this rule. The legendary scholar John Henry Wigmore flat out called it the most notable mistake in this whole area of law. So why was it so bad? Well, because it was clumsy, it was unfair, and frankly, it just didn't work.
This one bad rule created a whole bunch of problems. First, and most obviously, it totally killed the element of surprise. You're basically giving the witness a heads up to start thinking up an excuse. It also forced the lawyer into this procedural knot where they had to submit the entire document as their own evidence. And get this, if only one sentence in a 10-page letter was a lie, you might have to read the other 9 pages that actually made the witness look good. And funny enough, it could even be unfair to the witness by not getting them a clear, simple chance to just explain the contradiction right then and there.
Thankfully, the law doesn't stay stuck in the past forever. Today's rules are so much smarter and way more fair. So first, let's look at how the courts handle something a witness has said in the past, but maybe not written down. The modern way is this clean, 3-step process. Step 1, the lawyer sets the scene. They'll say something like, "Do you remember talking to Officer Miller on March 2nd right outside the coffee shop?" This gives the witness context. Step 2, they ask the direct question. "And in that conversation, didn't you say the getaway car was red?" And then step 3, the kicker. Only if the witness says no or gets all evasive, if they don't distinctly admit it, only then can the lawyer bring in Officer Miller to prove the statement was made. If the witness says, "Yeah, I said that," then that's it, job done.
Now, this is a really, really important point. When a lawyer does all this, they are not trying to prove the getaway car was actually red. The goal is to impugn the testimony. It's just a fancy way of saying to the jury, hey, listen, this person told one story back on March 2nd, and now they're telling you a different story today. Since they can't keep their story straight, maybe you shouldn't trust anything they're telling you now. See, it's all about credibility. So that covers spoken words. But what about that dramatic letter from the movies? This is where the modern law is just genius. It directly fixes every single flaw from that old broken rule from the Queen's case. I mean, just look at the difference. The modern rules are a total game changer. That element of surprise, it's back. A lawyer can ask about what's in a letter before handing it over. Being forced to submit it as your own evidence? Not anymore. The lawyer only has to produce the document if they actually want to prove the contradiction. And control, instead of reading the whole thing, good parts and bad, the lawyer can zoom in on those parts of the writing that actually contradict the testimony. It's surgical, it's efficient, and it's just so much better.
So when you put this all together, what does this whole journey from an Old English case to modern law really tell us? Well, it all comes down to finding the perfect balance between 3 really important ideas. So why does all this procedural stuff actually matter? Because these rules strike a really important balance. They make sure things are fair by giving a witness a clear shot to just own what they said. They bring back effectiveness by giving lawyers that powerful tool of surprise to really test if someone's telling the truth. And in the end, that balance helps the jury get closer to the real truth by giving them a much clearer picture of who they should and shouldn't believe. So the next time you see that big courtroom takedown, you'll know the intricate, strategic rules playing out behind the scenes. But it does leave us with one last question to chew on. When someone's story changes, does it always mean they're lying? Or is it sometimes just a sign of a faulty memory and the simple fact that we're all human? That's something for the jury and for us to decide. Thanks for watching.